Welcome to MSL Presents A Question of Law. The topic for today's discussion is sexual abuse of children. In the half hour that follows, we will explore, among other things, whether children who have been abused really can be helped, what effect the judicial process has on the victim, how to detect or prevent false accusations, the profile of an abuser, and why we don't punish family abusers more severely. Joining me today, Paula Dickinson, a professor at the Massachusetts School of Law in Andover, is the school's controller. She teaches juvenile law, the Family Law Advocacy Clinic, and is the director of the Research and Writing Program. Welcome, Paula. Judith Wolf is also a professor at the Massachusetts School of Law. She teaches remedies, motion and litigation practice, and asset planning and protection, and also is the director of the school's library. In her private practice, Judith represents parents in state intervention cases. Thank you for joining us, Judith. And Thomas Malone is an attorney who represents the Department of Social Services in state intervention cases. Tom is well respected by all attorneys for his work in care and protection cases, as well as termination of parental rights cases. Delighted you could be here, Tom. And I'm Diane Sullivan, an attorney and professor at the Massachusetts School of Law. Let's begin by discussing what is sexual abuse, what acts depict abuse, and what acts do not. Paula?
Good question, and we could go on for the half hour and more on what is sexual abuse, but it can run the gamut from anything from an offensive touching to rape. And I believe today it's much more criminalized than it had been in the past. And there are much more definitions of sexual abuse. For example, there are psychological definitions of what sexual abuse is and what the behavioral characteristics of children that have been involved in sexual abuse are, and so on and so forth.
And we will talk about some of those characteristics that indicate a child may or may not have been sexually abused before we close the show. Let me ask if this is accurate, Tom. On the one hand, would you say that sexual abuse could include just looking? On the other end, might perhaps be forcible rape, and everything in between could be sexual abuse?
Certainly any form of touching, Diane, would constitute that. Under the right conditions, something less than that might be tantamount to sexual abuse. If someone were even passively involved, for instance, in making a pornographic movie or something like that, that could constitute sexual abuse. Though more often, anything less than touching would be somehow neglect based on sexualized contact rather than sexual abuse per se.
So it might be prosecuted as neglect rather than prosecuted as abuse.
And we, the department, are not required, as the district attorney is, to adhere to strict statutory construction when making our own determinations about whether sexual abuse has occurred or not. Whereas the DA, in order to prosecute a sexual abuse case, would have to meet all of the specific elements of a given statute describing sexual abuse.
Let me ask you just one more question, Tom. In your experience, does sexual abuse generally start out with something simple, like giving a child a bath, and then escalate from there?
It's hard to say. I don't know that you could actually categorize it as a graduating, escalating series of events. There may be cases where that would be the case, but more often than not, we get allegations of actual, clearly sexual contact by the perpetrator or the alleged perpetrator on the child.
That's an isolated event that doesn't necessarily have a history building up to that?
Correct. At least when we first become involved, we seldom know what the history is. Perhaps after subsequent investigation, you can see it coming, but it isn't a natural progression from kind of peaking up to touching necessarily.
One of the typical, I'm sorry.
No, go ahead, Bob.
One of the typical kinds of cases, and I think in these kinds of cases, actually, the perpetrator and the family can be helped when the dynamics of the family, where mother is either absent or has some kind of problem, and oldest daughter somehow falls into that role, whether it has to do, it starts out with household chores, for example. Have you seen cases like that, Tom?
We have, yes.
And I think in cases like that, the family can be helped.
Well, that leads us to the next question. When the abuser is a family member, should the goal be to attempt to break the cycle by treatment, rehabilitation, and family reunification? Or should we punish the abuser for breaking the worst of taboos?
Well, look, I would like to have a moment here. Generally working with the parents, I hope that everybody in the audience can hear how terrorizing it is to have an allegation of sexual abuse alleged against you as a parent. It comes in, as Tom says, as some story from somebody. All of a sudden the seed is planted. It can be as vague as almost anything. Somebody walking by a room where something is occurring inside, but they didn't see it. So that you've got a parent that is working in the dark against God only knows what. Now, so there's different levels of sexual abuse, but the sexual abuse allegation, as it first comes in, seems to me colors the whole way that a family is in fact viewed. That is every single member of the family. So that when you say whether there should be rehabilitation and all, there has to be some kind of understanding about what's gone on. And what is culturally acceptable in one family and in one situation is not culturally acceptable in another. And those people that receive reports are generally from the same social strata in this particular country, so that we are so colored by our own feelings about sexuality in this country that folks that are under the gun with a small family may pay a price for which there would be no cost in another culture.
But Judith, let me ask you the question again in this way. Assume you're representing a parent, and you know, and the parent has admitted to sexual abuse. Should the goal of DSS, should the goal of the attorneys, should the goal of the DA be family reunification, or should we punish that abuser?
Not an easy thing to answer, because you're talking about things that go on between a parent and an attorney that is confidential between them. That's where we start. The second thing is, I suppose it has to do with the intention and the commitment of that parent toward that child and the rest of the parenting scene. Now, you can have a parent who is completely committed to that child, and there has been something going on. One of the things that comes up in a lot of my cases is evidently a child has an opportunity to view some sexual activity between parents, period. But that view has been expressed in a daycare or in a school or whatever. All of a sudden the family is suspect. Well, now, if it only amounts to making sure that there are closed doors or whatever, and housing situations which are generally smaller than the family needs, that becomes a difficult situation. So it's absolutely fact dependent, but it seems to me that there is a recognized constitutional right to parent your family, to manage it.
Not if you abuse them, Judith.
All right, now wait a second. We're talking about levels of abuse. We're talking about the ability of the human being to change. And if develops a concept that in the area of sexuality there can be no change in inclinations, then we have, as a society, closed out what could possibly be a successful human family relationship, because in fact reunification can take place. In fact, children and adults can work through these activities and come to respect each other. It takes time and it takes support by people who are committed to the time and the support.
The problem is the family is in a catch-22 situation in these sexual abuse cases, because you mentioned punishment and rehabilitation. Well, there are at least two different kinds of court cases going on. Dad, let's just assume he's dad, is involved in a neglect and abuse proceeding that was initiated by the department as a result of this alleged sexual act, where the goal, yes, is always family reunification.
Let me just stop for a moment and ask you for the audience, be sure we're clear on this. You're saying if a father, we'll say, sexually has assaulted and battered his daughter, the goal is always going to be family reunification?
It's going to be initially family reunification, at least, correct, Tom?
I think
at
in most
some
circumstances
point,
you could say that.
The department, and that point may be at the beginning as well.
It may be
the
relatively
department
early.
may take the viewpoint that we're going to terminate this guy's parental rights. Okay, but in most of the cases, their mandate, they've been set up in the early 80s, your family new agency, to help and rehabilitate families.
To me, though, sexual abuse of children is a repulsive crime, and I just wonder why we're talking about rehabilitating the family.
Well, the department's primary goal is to protect children, period. Our secondary goal within that is to reunify families or keep them together. That is a constitutional mandate, as Judith pointed out. But as between those two, keeping the family together or protecting the child, we have to side with protecting the child. We get a sexual abuse allegation. They are about the hardest things we have to deal with when it comes to preserving a family. If all the right conditions are present, if the alleged abuser owns up to the offense, is willing to go into treatment, if someone who is treating that person can give us something in the nature of a guarantee that he can be worked with, that there is a chance for rehabilitation, if the child is in the right kind of treatment, if the entire family is focused in just the right way, then reunification might be possible. I would say it is the minority of cases that you find that to be the case.
It seems to me, though, if sexual abuse is done by a stranger, immediately our reaction is to punish. But if it's a family member, then our reaction becomes to rehabilitate.
Because if sexual abuse is done by a stranger, we only have a criminal prosecution of that stranger. We don't have a family law case going on.
We don't have the continuing concern about the safety of that child. Once the child has been removed from whoever that stranger might have been, then it's assumed that the family is actually a safe haven. You don't have that where the perpetrator is a family member.
But Tom, in your experience, can children who have been abused ever really be helped?
Yes, absolutely, absolutely. It requires intensive treatment. The earlier you get it, the better. But yes, you can help these children. A lot of it has to do with overcoming the innate shame of these kind of acts, and with making the children understand that this is not what gets to happen to them as children, that what happened to them was first and foremost not their fault, and secondly was never supposed to happen. And the hardest thing we find is convincing the children that it wasn't their fault, and if the child is removed from the home as a result of these allegations, convincing the child that it's not the child's fault that the family has been broken up. With older children, that becomes a really serious problem, and you frequently find older children recanting the allegations that they initially made because they've seen what the effect has been of the allegation. They've broken up the family. Somebody in the family has been labeled as an abuser, is probably facing criminal charges, and they feel a tremendous sense of guilt, and they feel like they can fix this by just negating the allegations.
How sad.
Yeah, I had a case involving a 10-year-old boy and a 13-year-old girl, and they recanted as soon as they were taken to the DSS office within 24 hours after their initial interview by DSS.
And it does put us in a difficult position in court because usually you do not have physical evidence of sexual abuse.
So how do you determine sexual abuse has in fact occurred?
You go with what the child has said. If the child has said it under the right circumstances, and it's important to note, you have to look at all of the circumstances of the family and the allegations that the child has made in order to make a determination about the credibility of those allegations. You look at their behavior. Behavior is frequently a much better indicator that something has happened than a child saying something. A child may never say anything, but if they are conducting themselves in such a way that anybody with a decent amount of training would be led to believe that something has happened to this child, then I think you've got a fairly credible situation where somebody has been sexually abused.
What concerns me, though, is that a lot of those behavioral characteristics are similar to characteristics involved with other kinds of trauma.
That is true. You see a lot of the same things with post-traumatic stress
Right.
disorder, regardless of the nature of the trauma, but there is usually a sexualized content to the child's conduct, and it is qualitatively different than what you might see in a 3-year-old who is experimenting with a sister or with their own genitalia or something. I can't describe it for anybody, but if you looked at all the facts of each case, it's kind of like what Justice Holmes said about obscenity. You know it when you see it.
Changing topics a little bit, Judith, what effect does the judicial process have on victims? Is it almost as traumatizing as the abuse itself?
You know, we have, I'm going to make the position that we have more than one victim here. So we've got the judicial process as it affects the child. It has the judicial process as it affects the suspect parent with whom we're speaking today. I, of course, representing the parent, can speak, I suppose, more clearly to the effect on the parent as a victim, and I guess my position still has to be is I deal with more gray areas than I do with the egregious cases with which are easily resolved, I think, among all human beings. But for a parent does not get to know exactly the conditions under which the child is disclosing, what is affecting the disclosure. Under most cases, that's all silent. Immediately, the child is torn from the home, put into a strange situation, which its own kind of stresses, which victimize the parent. Visitation is limited, and so on. So they really have to work from a position of being absolutely victimized with no one actually to defend them. Again, for the child, the trauma of being thrown into a foster care situation, generally when the child is removed from the home, it's even from the contact from the parents. I mean, the parents are home and all of a sudden the children are gone. If they go off with just socks on, that's all they got, and that's all that you hear from there on in. So they have that kind of an environment. The parent then has to wonder what is happening in the foster care situation if that's where the child goes. What is that child being told? What kind of questions? What kind of response? There's all kinds of studies out there, as you well know, that a child, depending upon the age, can be influenced by having the same fact pattern set before them over and over and over until they begin to incorporate it as part of their real memory. So,
well, let me ask you, Judith,
yeah.
in your experience, are there many false accusations of child abuse?
I think so. Now, but again, you see, I'm hung up on what constitutes sexual abuse.
Well, how would you define it, Judith?
The easiest thing is what we've talked about, where there's no doubt about physical contact. That's the easiest thing. But when it just becomes
even that isn't necessarily easy, because sometimes, for example, evidence of certain types of infections may be sexual abuse, but maybe not as well.
That's true.
But anyway, go ahead.
That's true.
I mean, one thing we do hear a lot is, oh, I was putting ointment on the child, and that's why the child is alleged that she has been touched in an inappropriate way. Maybe that's so. In the cases I've done in upwards of 10 years, I've never seen a case that could be explained away by the application of diaper rash medication or anything like that.
In your experience, Tom, are children generally truthful?
I think more so than I think the public would guess. I think it may seem arrogant to assume that a child is telling the truth every time one of these allegations is made. But from hard experience, I've learned that it's equally arrogant, if not more so, to assume that they're not telling the truth.
But it depends on their age and the type of questioning they get.
Yes,
for example,
that is true.
There was some study done by, I think it was the University of Chicago. 4-year-old child asked the first question the first week, have you ever been in the hospital? Child truthfully says no. By the end of the second or third week, the child was answering that question by, yes, I caught my finger in a mousetrap and my brother did it to me, and et cetera, on and on and on, which happened as a result of a leading type of questioning.
And that's, you see that frequently. Frankly, most of it is the result of faulty investigative techniques. And when you asked your question before about the effect of the judicial process on the child, a lot of the way the system works now is geared to minimize the effect of the judicial system on the child and to minimize the possibility of these multiple questioning, bizarre answer scenarios.
How is that so?
For instance, if we get a report of sexual abuse, we have to, by law, make a referral to the district attorney. The district attorney's office has a team of experts in this area. They set up what they call the child victim witness interview. The child is interviewed once by a trained expert with everyone associated with that case who needs to hear what the child has to say, usually behind a two-way mirror, listening to what's saying, not interfering with the child. The child should not even know that they are there.
So would Judith be there if she were representing one of the parents?
No, she usually doesn't get that option.
No, she certainly doesn't get that option.
This is done.
And that's done so early on, though?
Right, that's very early on, and it's designed to, again, to have the child only go through this once to minimize the possibility of falsification by multiple questioning, confusing the child, and to minimize the trauma to the child.
Are those videotaped?
Sometimes. I don't know, because it's run by the district attorney's office, I don't know the parameters under which they use
You
that.
mentioned the district attorney's office, and I want to go back to a point you mentioned earlier. You said about dad or whoever owning up. And that's a difficult part, Diane, because for dad to own up and get custody of his kid or his kids back in the neglect and abuse case means that there's going to be an awful lot of information infiltrating through to the DA's office by law. By law, DSS has to inform the DA's office from the very beginning, from that first allegation of sexual abuse. The DA's office knows about it. So what is, again, your client is caught between a rock and a hard place.
Absolutely.
What do I do?
Absolutely.
Do I admit? If I admit, I'm going to go to jail.
That's exactly right.
And that puts us in a difficult spot because usually we cannot begin to consider reunification unless there has been something in the nature of an admission.
Attorneys that I have spoken with prior to doing the show have suggested to me, and I don't know if this is still the case, that oftentimes they might be representing a parent where there's accusations of sexual abuse, and DSS position is, we want to help you, we want to rehabilitate the family, you must admit they do, and they don't realize the criminal sanctions that will follow thereafter.
That is true. It is a very difficult position for everyone concerned.
And the trouble is, in my experience, perhaps the first interview, I know that there's an attempt to minimize this trauma on the child, is unclear, so they go back again. And so there is more than one interview, and unless things have really changed, the persons who interview, by their questions, suggest the answer. And then when they pull out these autonomic, well, you know, whether they're
anatomically correct dolls.
Yes. I guess I have hang-ups too, huh? Anyhow, when you pull those out and then all of a sudden the children are playing with them, all kinds of things are taken from that context. When that experience is obviously new to the child, curiosity, you got some strange adult taking a look at you and watching everything that's going on. And children, I'm sure, are very conscious of that two-way mirror. So, you know, the whole system is kind of artificially set up, and though the truth is what we all want to have, the truth is created in many different ways, and this one is very open to some kind of distortion.
Well, in most of these cases, nobody knows the truth, only the abuser.
And the district attorney, the child interviews that I have seen from behind the two-way mirror, they have not been conducted in a suggestive or leading way. Sometimes in the middle of the interview, it's been clear to everyone they're not going to get anything, and they simply kind of give up. It may well be that something has happened to that child, but I would say at least as often as not, there's the conclusion that either nothing happened, or if something did happen, we're never going to get to the bottom of it from talking to this child. So I think there's a notion that there are hordes of people ready to just kind of torture this child until they get what they want from them. And that simply isn't the case. I think the investigative techniques have matured in the last 10 years or so. You don't see the kind of cases like we had before with the daycare centers and that kind of thing. I can't think of the last time we've had one of those. And I think everyone has learned a lot from those cases.
And that is good news.
I believe that it is. Yes.
Let me ask you a different question. Do parents often or sometimes accuse each other of sexual molestation of their children in an effort to gain custody or to limit visitation?
We have seen that frequently. We are called upon often to go into the probate court where these issues of custody and visitation are usually fought out. And almost invariably we are brought in because sometime earlier there was an allegation by one parent against the other that he or she had sexually abused the child or exposed the child to sexual abuse.
And I think those are the cases where you see the most false accusations, not the cases that we've been discussing.
Yeah, I think that is correct. And I think if you look toward the allegations made, the statements made by the child, you can usually discern a lack of credibility by the proximity of the child's caretaker. The child is more often than not acting like a puppet. They're repeating things in an automatic fashion in a very kind of detached and unreal way, and it's usually under prompting by one parent or another.
I'm sorry.
No, that's okay. How can false accusations, Judith, be detected or prevented?
Well, that's the unanswerable question, or we wouldn't be having this discussion today. I suppose there's some element of time there that would make a difference. Tom has suggested cues about the way the reporter, the child, is behaving. He has also suggested that that can cut both ways, one that the abuse occurred and one that it didn't. It seems to me that there are enough professionals out there who have, in fact, had enough experience that they can, with some time with the child, make like an independent determination. In my experience, when the child is first placed in therapy, it's placed with someone who is like an advocate for the child. And go back to the mousetrap story that you talked about. It's my feeling from this level of professional that they see their role is to support the child, not ever challenge the child's sense of reality. So that if this therapist understood that the child was now saying the child had been hospitalized because of a finger in a mousetrap and knows clearly that this never happened, this therapist would never sort that out with the child at all. But if you get people who have a substantial and serious background in working with children in this area who are not their therapists per se, but they can in fact do something to sort out reality from what other influences that may be available.
Thanks, Judith. We're just about out of time, but I want to ask one last question. What is the profile of an abuser?
It could be any of us.
Is it typically, though, somebody who has been sexually abused as a child? Is it a predominantly male thing?
We do see a lot more allegations against males than we do against females. This does not mean that we do not get cases with female abusers.
The statistics are fairly high. I think it's 97% are males. Very high.
It is, I think you will find a history of sexual abuse in the background. I don't think it's safe to say that a child who was abused is automatically an abuser as an adult. I have seen at least as often that the mothers who were abused as children, though they did not sexually abuse as adults, they somehow created a situation where their own children were sexually abused. I don't believe they did it on purpose, but you see it.
That's why we have to break the cycle instead of punishment, instead of punishing.
So in summation, is it impossible to do both, to help it is, to help the child and punish the abuser? You cannot do both.
I think it's a rare day when you can do both. It is the ideal circumstance when you can do both, or I suppose there is no ideal circumstance when you're talking about child sexual abuse. But with just the right elements, you may be able to do both, but it is a rare circumstance.
And the last question I have, Paula, what about mothers who appear to be caught in the middle?
Very, very difficult. Just like them, in many of those cases, there's also domestic violence occurring in the household. And mom, because of her own problems, can't protect her child, and may lose custody as well.
We do put mothers in a difficult position. Because we are primarily concerned with the children, we usually offer them the choice. If an allegation comes up,
you should, I would think.
If an allegation comes up against the male in the home about sexual abuse, we will say either he leaves or the child leaves.
Take your pick.
Yes.
Okay, we're out of time. Paula, Judith, Tom, I thank you so much. And to our viewing audience, until next time, be well. Thank you.
Thank you.
Welcome to MSL Presents A Question of Law. The topic for today's discussion is sexual abuse of children. In the half hour that follows, we will explore, among other things, whether children who have been abused really can be helped, what effect the judicial process has on the victim, how to detect or prevent false accusations, the profile of an abuser, and why we don't punish family abusers more severely. Joining me today, Paula Dickinson, a professor at the Massachusetts School of Law in Andover, is the school's controller. She teaches juvenile law, the Family Law Advocacy Clinic, and is the director of the Research and Writing Program. Welcome, Paula. Judith Wolf is also a professor at the Massachusetts School of Law. She teaches remedies, motion and litigation.
Involved in sexual abuse and so on and so forth.
And we will talk about some of those characteristics that indicate a child may or may not have been sexually abused before we close the show. Let me ask if this is accurate, Tom. On the one hand, would you say that sexual abuse could include just looking? On the other end, might perhaps be forcible rape, and everything in between could be sexual abuse?
Certainly any form of touching, Diane, would constitute that. Under the right conditions, something less than that might be tantamount to sexual abuse. If someone were even passively involved, for instance, in making a pornographic movie or something like that, that could constitute sexual abuse. Though more often, anything less than touching would be somehow neglect based on sexualized contact rather than sexual abuse per se.
So it might be prosecuted as neglect rather than prosecuted as abuse.
And we, the department, are not required, as the district attorney is, to adhere to strict statutory construction when making our own determinations about whether sexual abuse has occurred or not. Whereas the DA, in order to prosecute a sexual abuse case,
helped when the dynamics of the family, where mother is either absent or has some kind of problem, and oldest daughter somehow falls into that role, whether it has to do, it starts out with household chores, for example. Have you seen cases like that, Tom?
we have,
Where,
yes.
And I think in cases like that, the family can be helped.
Well, that leads us to the next question. When the abuser is a family member, should the goal be to attempt to break the cycle by treatment, rehabilitation, and family reunification? Or should we punish the abuser for breaking the worst of taboos?
Well, look, I would like to have a moment here. Generally working with the parents, I hope that everybody in the audience can hear how terrorizing it is to have an allegation of sexual abuse alleged against you as a parent. It comes in, as Tom says, as some story from somebody. All of a sudden, the seed is planted. It can be as vague as
would have to meet all of the specific elements of a given statute describing sexual abuse.
Let me ask you just one more question, Tom. In your experience, does sexual abuse generally start out with something simple, like giving a child a bath, and then escalate from there?
It's hard to say. I don't know that you could actually categorize it as a graduating, escalating series of events. There may be cases where that would be the case, but more often than not, we get allegations of actual, clearly sexual contact by the perpetrator, or the alleged perpetrator, on the child.
That's an isolated event that doesn't necessarily have a history building up to that?
Correct. At least when we first become involved, we seldom know what the history is. Perhaps after subsequent investigation, you can see it coming, but it isn't a natural progression from kind of peaking up to touching, necessarily.
One of the typical, I'm sorry.
No, go ahead, Bob.
One of the typical kinds of cases, and I think in these kinds of cases, actually, the perpetrator and the family can be
practice and asset planning and protection, and also is the director of the school's library. In her private practice, Judith represents parents in state intervention cases. Thank you for joining us, Judith. And Thomas Malone is an attorney who represents the Department of Social Services in state intervention cases. Tom is well respected by all attorneys for his work in care and protection cases, as well as termination of parental rights cases. Delighted you could be here, Tom. And I'm Diane Sullivan, an attorney and professor at the Massachusetts School of Law. Let's begin by discussing what is sexual abuse, what acts depict abuse, and what acts do not. Paula?
Good question, and we could go on for the half hour and more on what is sexual abuse, but it can run the gamut from anything from offensive touching to rape. And I believe today it's much more criminalized than it had been in the past. And there are much more definitions of sexual abuse. For example, there are psychological definitions of what sexual abuse is and what the behavioral characteristics of children that have been